Good afternoon. I'm Jocelyn Kennedy, the Executive Director of the Harvard Law School Library. Welcome to our first Harvard Law School Library Faculty Book Talk of 2022. Some housekeeping notes. This talk is being recorded and will be posted on our YouTube channel. Check out our Scholarship at Law blog for more information on that. I want to thank Dean Manning for his generous support of these talks, and a really big thank you to our team, Maya Bergamasco, Anna Martin, Rachel Parker, Teresa Knapp, and Debbie Ginsburg for helping to put together this series. We welcome questions for our panelists and invite you to use the Q&A feature throughout the talk. We've reserved time at the end for our panel to engage with your questions. Please visit your local library or your local bookseller, including the Harvard Coop, for a copy of today's book, Civil Rights Queen, Constance Baker Motley and the Struggle for Equality. To begin our program, I'd like to turn it over to our moderator, Professor Kenneth Mack. Professor Mack is the inaugural Lawrence D. Beale Professor of Law and is an affiliate professor of history here at Harvard. He's an award-winning author for his book, Representing Race, The Creation of the Civil Rights Lawyer. His research and writing focuses on American legal and constitutional history with a particular emphasis on race relations, politics, and economic life. Professor Mack, I will turn it over to you. Thank you.
Yeah, thank you, Jocelyn. And it's a pleasure to be here to have a panel on such a wonderful and wonderfully important and topical book. Our session is going to begin with our three commentators, going in the order of Professor Cheryl Cashin, Professor Evelyn Brooks Higginbotham, and myself, commenting on the book. Then we'll have a brief response by Dean Brown-Nagin, a little bit of back and forth, and then we'll have questions from the audience. So I'm going to briefly introduce our panelists. Cheryl Cashin is the Carmack Waterhouse Professor of Law, Civil Rights, and Social Justice at Georgetown University, and is the author of, among other things, White Space, Blackhood, Opportunity Hoarding and Segregation in the Age of Inequality. Evelyn Brooks Higginbotham is the Victor S. Thomas Professor of History and of African and African American Studies at Harvard University. Among her many accomplishments, she's the author of Righteous Discontent, The Women's Movement in the Black Baptist Church, 1880 to 1920, and the current edition of From Slavery to Freedom, A History of African Americans, which of course was first published by John Hope Franklin in 1947. And I'm Kenneth Mack. So we're going to go in order. Professor Cashin is going to be first, Professor Higginbotham is going to be second, and I'm going to be third. So I'll just turn it over to Professor Cashin to start our commentary.
Thank you so much, Ken. I am delighted to do this today for my friend, Tomiko Brown-Nagin, and I'm delighted to share this panel with these wonderful professors. So what an auspicious time. There's been much discussion about Black women in the news, but to comment on a book about the first Black woman nominated to the federal bench at a time when Black women are being discussed to be considered to be nominated to the Supreme Court. And, whether you're running for governor of Georgia in 2018 and being called not qualified by the President of the United States, or on the short list to be considered for the Supreme Court and being deemed lesser than, or being nominated to the Federal Reserve Board and being attacked as not qualified, we're seeing a lens of automatic assumptions about Black women as lesser characters. And this is in the 21st century. And imagine what the Queen, and I love this, I'm showing it because it's such a beautiful book and a beautiful cover. Imagine what it was like for the Queen, who was a pioneer her entire life. And, these automatic assumptions are very different from the automatic assumptions I have about Black women, based on intimate experience and frankly, based on being one. I see Black women as the people who work twice as hard, who hold families and movements together, often without full credit. And, now we have this wonderful book where I think the author and the subject exemplify our sisterhood's history of excellent, exceptional contributions to the American experiment. And so I want to begin by reading the blurb I wrote for this book. I wrote a brilliant work, elegantly written. Oh, wait a minute, that's Annette Gordon Reed's blurb. Sorry about that. My blurb. A brilliantly researched and riveting biography. Brown-Nagin models the care, preparation, excellence of Motley. Through a decade of effort, she has written an instant classic that rightly places Motley at the center of the American struggle for racial justice. I also, and this is something that got edited out of the blurb I wrote, but I said Constance Baker Motley's relentless shattering of white supremacy and patriarchy for others was also a triumphal demand for respect, freedom, and equality for herself. And boy, can I relate to that. You know, I read this, I couldn't put it down when I was reading it. And part of what I was doing is I was reading, like, how did she do it? How did she do it? And it was so inspirational to just watch her going through the stages of her life. And Tomiko does a masterful job of showing her in all of these eras of her life, you know, this fortitude of just not seeing any limits for herself and doing the work was so inspirational and so well done. And, you know, in concluding, I want to focus on or comment on a particular chapter. I had the great and awesome pleasure of clerking for Thurgood Marshall in his last active year on the court. And I actually once asked him, Tomiko, in his chambers with no one else around, to his face, why he chose Jack Greenberg as his successor. And Justice Marshall quickly and a bit defensively said, well, I just thought he was the best man for the job. That's what he said. And it felt like a very long process, long practice answer. And so, you know, you do a great job in that chapter of showing that Justice Marshall, Thurgood Marshall, who gave Motley her chance to be a lawyer and believed in her intellect. And I felt that myself. He gave me my chance, hired me, and treated me as just as equal. Sometimes I felt like he treated me like I was not lesser than, but above everybody else in the chambers. But I just think it was beyond his imagination then to put a woman in charge, and that's basically what Motley said. And so I'll conclude by saying that again and again, and yet, you know, I'll say, you know, he sent her down to the South again and again to undertake some of the most dangerous assignments. And I think, again, we're still at this moment where Black women have to prove themselves. And I really am excited that you have this stellar example out there that we can all point to, undergirding that we come from an excellent sisterhood, and she's the queen. So thank you.
Well, thank you. It's also quite an honor for me to be here. And Tomiko, I don't know if I ever shared this with you, but I first met Constance Baker Motley in October 1975 in Atlanta, Georgia, at the annual conference of the Association for the Study of African American Life and History. I had begun my doctoral studies a month earlier at the University of Rochester and hoped to become a pioneering figure in then the little recognized field of African American women's history. She was best known to her audience as the great civil rights lawyer who successfully challenged segregated white universities in the South and had won the court cases of Black students like Charlene Hunter Galt and Hamilton Holmes at the University of Georgia and James Meredith at the University of Mississippi. In 1975, however, Motley stood before her large audience, not as a lawyer, but as a federal judge on the district court in New York. Her presence at the conferences, or as the conference's keynote speaker in the grand ballroom of a racially integrated hotel in downtown Atlanta, exemplified the great changes in the civil rights and voting rights of Black people over the past decade and epitomized the historic contributions that she made toward those very changes. Seeing her and listening to her speak gave me a sense of affirmation as to the historian I sought to become. Her life validated the subject matter I pursued. Tomiko Brown-Nagin has done a great service by bringing to light and to visibility Motley's life story, a story previously minimized or worse yet, overlooked in history books. Given Motley's accomplishments as a civil rights lawyer, Manhattan borough president, and federal judge, her impressive list of gender and racial firsts has been overshadowed by a focus on the male lawyers with whom she worked, and especially overshadowed by Thurgood Marshall, whose place in history has taken on a magnitude that dwarfs other key people who worked with him. I think also of Robert Carter, who is deserving and in need of a big biography. For a long time, and still today, the civil rights movement has been written about in terms of great men. The larger public's remembrance of the movement reflects perhaps even more the great man in history, as can be seen with Thurgood Marshall and Martin Luther King and Malcolm X. And I don't want to take away from their greatness. But what I admire about Brown-Nagin's civil rights queen is that she has opened up the life and work of Constance Baker Motley in a way that enlarges our view of Motley's experiences, her thoughts, her family life, her challenges, her mishaps, her resilience, her tenacity, her ambition, her frustration, her hard work, and her self-confidence. One of my favorite lines in the book is Motley quoted after winning the University of Georgia case in 1961. And I quote it, "It wasn't that we outsmarted the state," she insisted. "You win by preparation and experience. While they were looking up cases in the law books, we were calling them off by heart." Much like the way we enlarge images on the screen of our laptops or iPhones or iPads to see with greater focus and clarity details we would otherwise miss, Brown-Nagin has enlarged the image on the screen of Motley's life so we can read her more clearly, see her more keenly. But what is equally interesting to me is that by doing this, Brown-Nagin has also made visible the local lawyers and plaintiffs around her, the many people whose courage to fight for racial equality brought Motley into their struggles and into their stories. In the 21st century, civil rights scholarship has disclosed on-the-ground direct action in local communities and local legal campaigns for racial equality in schools, hospitals, transportation, places of recreation, voting rights. Together, those stories comprise the civil rights movement and the civil rights era that buoyed up national leaders. And from the local perspective, women have begun to appear in the history books as never before. Tomiko Brown-Nagin builds impressively on this scholarship by further opening up and enlarging Motley's persona in higher definition as a national figure engaged with local people who appear more prominently rather than shrink in importance. And thus we're able to see more fully the complexity of the legal landscape that includes their lives and hers, and the complexity of their emotions and hers. I love the chapter titled, "We Made a Mistake, Poor Character, Loose Morals, and Untold Sacrifices in the Pursuit of Higher Education at the University of Alabama." Brown-Nagin focuses the failed efforts to desegregate the University of Alabama in 1956, and she discusses authoring Lucy's flawed co-plaintiff, Polly Myers, who was dropped from the case because of the school's discovery of her pregnancy before marriage. Now, this chapter speaks to a concept that I theorized in a different context, but nonetheless, the concept of the politics of respectability, which Motley firmly embraced. Next year, when I teach my course, African-American Lives in the Law, we will read Civil Rights Queen, and I will have my students debate the legal strategy of the model plaintiff, given the mores of the time, the 1950s, and given the specific use of moral character certification by the racist school administrators and the state to thwart integration. The book Ground Crew, The Fight to End Segregation at Georgia State by Maurice Daniels focuses on the case Hunt v. Arnold. This was in 1959. And he quotes the Georgia lawyer Donald Hollowell, with whom Motley also worked on this case too. And this is what Hollowell says: the moral issue was to become a favorite ploy of the Attorney General's office and other lawyers of the state during the years to come. So segregationists would look for anything, everything, as results pertaining to a plaintiff. And the result led Motley and the LDF team to try to scrutinize as best they could the backgrounds of their clients. Well, the Georgia state case is similar to the story of Polly Myers in Alabama, although Myra Dinsmore, one of the plaintiffs with Barbara Hunt and another woman, in this Georgia case, she does express being very much emotionally supported by Motley. We tend not to think of court cases as being painful and dangerous, especially when compared to the direct action campaigns in which people put their very bodies on the line. But Brown-Nagin portrays vividly the fatigue and the demoralized spirits of plaintiffs who faced relentless, time-consuming obstacles in court. Sometimes it took years. The humiliating newspaper articles, not to mention fear from riots and death threats, and all this simply to go to school. In fact, Motley received death threats. I loved Brown-Nagin's description of Motley as morphing from the role of lawyer to that of counselor and comforter during those times when her clients found themselves in a bad place emotionally. And she describes this for a lot of people, including James Meredith. Motley was personally invested in them, just as she was invested in justice. And the final enlarged image I want to talk about is the power of Motley to inspire courage. Brown-Nagin describes the courtroom in Jackson, Mississippi in 1951, filled with Black onlookers who came to see Robert Carter and Motley challenge the unequal pay between Black and white teachers, the Bates case. However, Brown-Nagin does more than discuss their arguments before the judge. She writes that they, and I quote her, they embolden the African Americans who eagerly watch the civil rights lawyers' performance each day. The Jackson community's excited reaction convinced Motley that both outside and inside the courtroom, lawyers functioned as translators of local people's grievances and catalysts for change. So I end with this image of her and her audience, because that was my first image of Motley at the Black History Conference in Atlanta in 1975. On that occasion, Judge Motley spoke on the meaning of our nation's upcoming bicentennial celebration. Her speech was titled The Quest for Freedom, 1776 to 1976, The Continuing Revolution. And in that speech, she said, we are now a multiracial, multicultural, and multi-ethnic body politic struggling to make democracy work. I love that line. Her words are as true today as they were nearly 47 years ago. We are still struggling to make democracy work. Thus, when I read Tomiko Brown-Nagin's carefully researched, brilliant, beautifully written biography of Constance Baker Motley, I cannot help but think of Motley's words and her heroic and tireless lifetime struggle to make democracy work. Thank you.
Well, of course, it's a pleasure for me to be here as well. Dean Brown-Nagin and myself, our scholarship has followed parallel tracks for a long time. Very much interested in the subject matter. I wondered so much about Constance Baker Motley over the years, and I learned so much from reading this book. I'm going to sort of focus on, start with the title of the book, The Civil Rights Queen. That's taken from a phrase that people use to describe Motley. But it also seemed to capture much of her persona, her public persona at least, as Brown-Nagin argues in the book. She was regal, she was well-dressed, she was reserved, she was light-skinned, an era in which people connoted skin color with beauty. And people talked about her appearance all the time, newspaper articles, etc. And actually in each of her professional iterations, both as an NAACP lawyer, as a politician, and finally as a federal judge, this quality of being a civil rights queen manifested itself, and it was necessary because she did some really challenging things. As has already been mentioned, as the first Black woman hired as a lawyer by the NAACP, who won 9 out of 10 cases in the Supreme Court. As a New York State Senator and a Manhattan Borough President, just as the power structure in the city was changing to partly accommodate Black residents. And finally, as the first Black woman federal judge, serving as many issues connected to the social transformation of the society in that period were coming before her as a judge. And I should note that this persona of the civil rights queen is actually strikingly similar to that of the first Black woman judge in American history, Jane Bolin, who became a judge in the New York Domestic Relations Court in the late 1930s. Like Bolin, like Motley, people commented endlessly on Bolin's appearance. She was tall, she was light-skinned, she was well-dressed, she was quite formal. A little bit different, but actually still a little similar, was Sadie Alexander, a noted Black woman lawyer in Philadelphia, who became one of the leading civil rights figures in the middle of the 20th century. I take it that the thesis of the book, or one of the theses of the book, is that this persona, it's armor in an unfriendly world. It's a way of navigating a world as a Black woman lawyer in this era. Now, of course, the persona is not only shaped by being a Black woman lawyer. You know, it doesn't overdetermine how they acted, but it's part of it, right? So as the book makes clear, Motley was raised by parents. They were immigrants from Nevis and the West Indies. They were very formal people. They regarded themselves as subjects of the British Queen. She had a domineering father. There are other ways in which that kind of formal, reserved personality, other sources for it. Jane Bolin and Sadie Alexander likewise had very respectable upbringings and backgrounds. Bolin was the daughter of a Black lawyer who became one of the leading lawyers in his locality, Black or white. And Alexander came from 2 very prominent families. So you know, this persona, you know, there are other things that drive it, but part of it is about being a Black woman lawyer. And the book uses, you know, this idea of the civil rights queen. It uses it, and it evokes James Baldwin's famous essay, "The Price of the Ticket," to think about, you know, what is this question, this problem, the struggle of being a Black woman lawyer. Baldwin, of course, talked about the costs of integration to whites and to Black people, and the cost of Blacks by judging themselves by the standards of those who believed that they were white. So Brown-Nagin's book is asking, at what cost do outsiders become insiders? And it has some very specific things to say on that. Quote, when icons of opportunity and diversity take the reins of power in American institutions, the structure envelops them, close quote. Or quote, when the system admits outsiders who play by its rules, fits them into its logic, and permits incremental reform, the power structure does not fundamentally transform at best, right? That structure itself doesn't transform itself. At best, it accommodates difference, close quote. So a couple of queries, just following up on this. What is the price of the ticket? The book asks. What's the price for outsiders becoming insiders? Motley doesn't seem like a very transformational person, even before she becomes a lawyer, right? This isn't the case of de-radicalization, someone who actually sacrifices their goals or is changed by being in the system. As the book, very forthrightly brings out, Motley's upbringing was very much consistent with how she acted as a lawyer. It's formal, it's reserved, it's respecting of existing institutions, even though it wants to change them. So I wondered, should one append the thesis of the book? It's less the case of the structure enveloping outsiders than outsiders who have already learned to play by the logic of the system's rules being admitted to the system. And then I wonder, well, are these really the system's rules? As the book points out, there are a lot of different subcultures in Black America. The subculture of West Indian immigrants, differing attitudes towards second wave feminism that many of the leading Black women figures of Motley's era had. And of course, Brown-Nagin wrote another prize-winning book on exactly this thesis, the kind of many cultures and perspectives within the civil rights community. So maybe it's the case that people like Motley, that these are outsiders whose own subcultures have some homology with the system's rules, and that these are the people who are most likely to succeed in the system. So if that's the case, I don't know, this might be less the case of the system exacting a price for admitting people than the system admitting those who already believe that the price to be exacted is smaller than it otherwise might be. Now, none of this downplays just the immense difficulty of Motley's position and the immense courage that it took to do the things that she did. They'd be daunting for any of us to try to do those things. But maybe the system isn't as exacting as high a price or as much of a cost as it might seem. And finally, I'd like to just kind of briefly point out that there's a kind of irony in this book. It's really interesting. The cases that bring Motley to prominence are the university cases in the 1960s. It's James Meredith, it's Charlene Hunter, and Hamilton Holmes at the University of Mississippi and the University of Georgia. Now, if you were a male NAACP lawyer in the 1950s looking at your agenda, you would think your agenda is to implement Brown. But it's kind of odd that, in fact, these cases in some ways are throwback cases, right? The NAACP used to bring the university cases in the 1940s. And then in the 1950s, it focuses on Brown, although there's Arthur and Lucy, there are other cases. But Motley becomes a public figure partly by taking on these cases that if you were an ambitious man in the NAACP in the late 1960s, you wouldn't think that this is the route to prominence, but it becomes so for Motley. So it's a really interesting and ironic and counterintuitive development. But so many things about Motley's life were. Thanks for a wonderful book. Next, we're going to have short response by Professor Brown-Nagin, a little bit of interchange among the panel, and then we'll open up for questions. Remember, you can submit questions, and then we'll talk about them during the discussion period.
Well, thank you so much, Ken, Evelyn, and Cheryl for those comments. They're so insightful. I just enjoy hearing you reflect not only on my book, but on some of the themes that you've explored in your work. And of course, this book does build on a significant scholarship exploring themes like representation, respectability, and the extent to which our civil rights laws facilitate the achievement of the conception of equality, not only that lawyers want, but that communities need, which is a theme I've seen in Cheryl's work. And before I engage some of the comments that you made, I do want to start by thanking the Harvard Law School Library. Thank you, Jocelyn, for inviting me. And I want to say thank you to all of the librarians who helped to make this book possible. You know, at one point, you might have thought I was a full employment program for the Harvard Law School Library because of the volume of requests that I made. And I'm truly thankful to you for all that you did to help me bring this book to fruition at a moment that is quite timely, as Cheryl started and sang. And I imagine that many of the questioners will want to explore the relevance to the pending Supreme Court nomination. So I will hold my thoughts about that and the parallel with Motley to the audience questions. I have lots of thoughts, as you would imagine. And I will engage Cheryl's comments and Evelyn's comments by absolutely affirming that Motley is an inspirational figure. And I did want to, in writing this book, write a story that inspires, even as it engages questions that are fundamental to our time, that reflect on debates in the civil rights historiography, in anti-discrimination law. So it's both a life, but it's also an exploration of these broader issues. Now, it is not meant to be, and it isn't a hagiography. So in the chapter that Evelyn pointed out about the University of Alabama case, I certainly seek to understand Motley in her context. So she believes in the politics of respectability. But I do think it's important as we write these books about the civil rights movement, the women's rights movement, any of these movements, to talk about the human costs for those who were involved. And there was a cost to Polly Ann Myers and so many other women. And those costs often reflect gender stereotypes, as we saw in that moment. And as is often the case, and certainly I wrote about this in my prior book, there is not a perfect unity of interest between even the lawyers and the clients. The clients don't go into these cases, I don't think, and certainly didn't then, truly understanding what it would mean to have one's life on display in the way that was required for those cases. And so I do just raise a question, and Evelyn, you answered it in part by talking about the Hunt case. Just a question about, well, I'll just call it again, just the costs and the lack of pushback on Motley's part in this case against those norms. I wouldn't have expected her to, because she's wearing her lawyer's hat. And as I argue in the book, it is so important for the NAACP Legal Defense Fund to choose the right plaintiffs. And so Charlene Hunter Galt and Hamilton Holmes, they are just terrific plaintiffs, right? They are smart, they're from good families. Appearance matters. And they're, they're good looking, attractive young people. As I say of Hamilton Holmes, he looks like the all-American young man, except for the fact that he is, he's coded African-American. And what else can I say? I'll go to Ken's remarks, complexifying the notion of the cost of the ticket. So you certainly have your finger on something. And I'm not sure to what extent I engage it in that epilogue, but it has to be the case that there are only certain kinds of people who wind up in these posts, right? The exchange happens much earlier, right? In terms of culture, norms, goals, objectives. Motley was ambitious. She was from this West Indian family where the father taught her to think of herself as superior. I happen to think that it was useful for her when she went to Jackson, Mississippi in 1951 or in 1962, where I tell stories about how the white male lawyers are representing the University of Mississippi, for instance, they don't shake her hand. They don't want to shake Motley's hand. And she's truly puzzled by this, right? Because she can't understand how the lawyer doesn't appreciate, well, she graduated from Columbia Law School. And she's of the West Indian bakers from New Haven, Connecticut. And all of her male relatives worked at Yale University, where they read the prestige of the white men, young white men, who were their charges into themselves. And so there's a way in which there's utility to that. And I certainly understand and agree with what Mary Waters said about Caribbean immigrants, and that is that in the end, they're immigrants, right? And in this country, it is often the case that immigrants are taught to and do read themselves against African Americans. All of these women, they are playing from the same script. And the interesting thing is, as you were pointing out, Ken, in relation to Motley and her family background, is it that the conformity to respectability and the access reflects pre-existing personal notions, or is it that there's a functionality to the way in which these people perform race and gender? And it's likely both. As to whether Motley's transformational. I do think that she's transformational in the context of her lawyering, just by virtue of who she is. I mean, this is a Black woman who goes into these courtrooms in the Deep South, and she has the, in the University of Georgia case, she has the judge giggling because she's showing so much intellectual command, and she's just so brave. It's helpful for her to be nearly 6 feet tall. She's just a physically striking person, and she's doing things that are just, they're out of place. She's not meant to be doing these things according to the conventions of America at that time. And so I do think she's transformational. When she is a lawyer, she is the gladiator that people often imagine civil rights lawyers to be. She's working, I think, in that terrain. But certainly, as I say, as she moves into politics, which she has access to because she is appealing to the liberal establishment in New York, white liberal establishment, Black establishment, they can see immediately that she is just, she's sensational, she is smart, she is excellent, she has name recognition, and so she's a great candidate to put forth. And then when she goes into the court, She is a part of the establishment, doesn't make any apologies for that. Not sure that she should, because a part of what happens with these representatives is that people foist onto them their own expectations and values. When we know that judging requires conformity to certain norms, to precedent for most judges, certainly on the district court, to professional norms. People are ambitious, they want to be promoted. And then there's all that Motley thought about, what a judge should be and do. And so she does end up both deciding some cases that are landmark cases in the anti-discrimination jurisprudence. On the other hand, most of the time she looks like any other judge. And that is both going to be and is meant to be comforting, but also disappointing. And I'll stop there and ask you if you want to engage further in any of those comments.
Well, I think what we should do is I want to remind the audience that you can submit questions for the panel, for Dean Brown-Nagin, for any of us, for all of us, through the Q&A function, and really encourage you to do this. But I see Cheryl, you've got your hand raised.
Yes. So there a question I'd like to raise with you, Tomiko, is that we haven't discussed it. It seems to me that a big part of Constance Baker Motley's success over her career, it's uncomfortable to say it, but she married the right man. In the sense that, I don't see how she could have been as successful as she was had she not married the guy she married, who did not seem to have any desire to do anything but support her and let her be who she wanted to be. And that also enabled her to be a wife and a mother, which society kind of wants women to be. So she was the whole package. I'm reminded of how much Amy, the most recent nominee to the court, her being a wife and mother was a part of the package. So I'd like to hear what you have to say about that.
It's certainly true that she could not have been the person, and she could not have accomplished what she did without her husband, Joel II, who was from the Midwest. His own family background, including the experience of having a mother who he was separated from pretty early in his life, shaped his own personality, and they made a great match. He did not feel the need to dominate her in the way that Motley's father dominated her mother. He earned a good living as a real estate broker in Harlem, and yet he was able to have flexibility because he owned his own firm, and he was content to support her. And so I do, in a chapter about their marriage, talk about how uncommon it was to have an egalitarian marriage at that time. I don't think, Cheryl, that I think we should talk about this, right?
Mm-hmm.
That the choice of a partner is a vital part of the package. If people haven't figured that out or don't figure it out pretty early, in their careers, it's important to know. As for the wife and mother, so she was a non-traditional, not only wife, but mother. And one of the points that I make in the epilogue is how it sat uneasy with her. Although she did all these things that were unconventional for a woman, and she was very confident, at the end of the day, she also said that, her greatest accomplishment in life was raising her son and him turning out well, even though she wasn't home a lot of the time. And so that just speaks the discomfort with being non-traditional. And yet I do think that being a mother, having a partner like Joel were vital to her success, as well as all of the, the issues around appearance.
Okay, I think Evelyn has a question, and then we've got 3 in the queue. So go ahead, Evelyn.
Right. So mine, just to piggyback and then go slightly in a different direction. But you do have other women. You mentioned Sadie Alexander. Now, you didn't mention Sadie's husband, but Judge Raymond Pace Alexander was a pretty important man. And so they were married. I mean, you do have these combinations. It's exceptional, but it's not unheard of. Or I think of Patricia Roberts Harris. A lot of women who made a way for themselves, and somehow they worked it out at home. I don't know how easily it was, but they did it. But my point, and it does relate to this in another way, because we haven't raised it. She was very outspoken in the sense that she said, "I'm not a feminist." She would have attained all the heights that the goals of feminism would have wanted, but she was really clear that the racial struggle, she kind of reminded me of the famous lines by, I think it's Frances Ellen Watkins Harper, who's quoting Martin Delaney, who says, "The when and where I enter, if I can enter in a room as a Black woman and nobody notices, then, sure." But she was first and foremost interested in Black women, Black men. She's very clear about that. She's not a Polly Murray by any stretch of the imagination. Could you talk just a little bit about that? Did they, I just wondered, did they hang out together? Did they talk at all? Did they, because, Polly went to Howard, so law school. So there were many ways that their lives would cross paths. I even remember reading something where Constance Baker Motley wrote about the Civil Rights Act of 1964 and how the women question was brought in to dismantle it. But we know that Polly Murray was one of the great voices for the women issue in the title, I think it was the Title 7. Yeah, in that. So it just strikes me that it's unusual for her to be just so outspoken. "I am not a feminist."
Yeah, great question. And Evelyn, I connect her saying that to her time in politics. She's very conscious, as your story related, to needing to appeal to multiple constituencies. And that was certainly true when she was in politics. It was in 1964, 1965, so well before the women's liberation movement had fully flowered, and it made sense for her to take that stand. I already have enough going on. Please don't call me a feminist. I can do without that. I do think, though, that in terms of what she achieved and her policy positions and the work that she did on the court to enforce Title VII of the Civil Rights Act, the anti-discrimination employment element, she didn't spend time, I say, articulating her feminism. She just did it. And a further point that I make in this book is just about the varieties of feminism. So you have Polly Murray and maybe Shirley Chisholm on one end, and then people like Motley on another end, but they were all friends. They knew each other, they cheered her on. Polly Murray did, Shirley Chisholm, who overlapped with her in the New York legislature. And it seemed as if they gave each other space to approach this particular issue as they thought they should, which is I believe, a nice thing to see. People having a common commitment to equality, but giving each other space to pursue it in the manner that they saw fit, and with acknowledgement that it's one thing to be a civil rights lawyer, it's another to be a public official, and then another still to be a judge. Thank you for that comment.
Okay, so we have a few questions in the queue. So in the interest of time, I'm going to combine two questions and pose them to the whole panel. Anybody who wants to respond, but particularly Dean Brown-Nagin. So one of the questions is about just, today, well, the thing that we've referenced, our pending Supreme Court nomination. The first question was, does history have anything to say to this? Or is this moment so different than the moment that Constance Baker Motley was in that, we can't derive any lessons from it? How do we think about that? And then the second question is more specific, assuming we can derive lessons from it. What does Motley's confirmation battle and her challenges to her tenure as a judge, and also Thurgood Marshall, who everyone remembers had a quite contested confirmation battle as well. What does that portend for the pending confirmation, the pending debate about the confirmation of whoever President Biden chooses to nominate? So first, is history relevant to our moment? Second, does it teach anything about what we're going to face in the confirmation battle? Anybody wants to respond, but particularly Dean Brown-Nagin.
Sure, I can respond briefly. I would say there are things that we can learn from Motley's confirmation fight. First of all, we can learn that it was a fight. There were those who thought when she was nominated that she would just sail through. That did not happen. Senator Eastland of Mississippi, who was a segregationist and who he did not want the nomination of the Black woman who would kill Jim Crow at his alma mater, the University of Mississippi, to just slide through. And so he cast aspersions on her character. He said that she was a communist, which is just a pretext, right? That was used against a lot of African Americans and people in the civil rights movement. Moreover, there was some jockeying, and her nomination was actually two-part. She was initially considered. Johnson wanted to appoint her to the Second Circuit, but there were those, including among Democrats, who pushed back, saying that it would be problematic and seen as too political to promote Marshall to the Solicitor General position, while also appointing Motley to the court. There were those who just misrepresented her record. So the ABA rated her qualified instead of highly qualified, saying that because she hadn't practiced in federal court in New York, that somehow made her less qualified. Of course, she had practiced in federal courts across the nation. She had litigated. She had more experience than many of the people who were being appointed. And so it's just a distortion. So I don't want to take up all the time. I'll just say that one could expect, given the conventional racial scripts, and we've already seen that there will be those who mischaracterize various the records of some people on the list. There is the always the resort to unqualified. I'm so pleased that in the case of the women whose names are on the short list, there are people who are eminently qualified. And so I think, as I'm thinking about Mississippi, that dog won't hunt, as they say. I think we're going to see someone who is nominated who will get a lot of support, but one has to run the gauntlet first.
Others want to jump in on this?
One of the things that I find amazing is that in this earlier era, in the 60s and even in the 70s with Carter, that you had nominated people whose records were very firmly in the civil rights struggle. So my late husband, Elian Higginbotham, was, among other things, the president of the Philadelphia NAACP branch when he was first, Kennedy first put him on the Federal Trade Commission, and then he nominated him for the district court. Just so many of them. I mean, not only Motley, Robert Carter. I think of Nathaniel Jones in the 70s, Wade McCree. Just a bunch of people who you could not do that today. There is no way in this world, if you had a prominent civil rights, you probably couldn't even give it if they saw you donated to the NAACP LDF. It's just amazing how different it was then than we have it today. When they come to talk in the hearings, they have to be so careful about their positions on so many different things. So for this whole generation of civil rights judges, as I'll call them, the big question was, would they only be doing civil rights? And as you showed, they had a breadth that took them well beyond civil rights, but the fear from those who opposed them was that they would do civil rights. Now you have to almost be nominated with the idea that you never did civil rights. Or am I exaggerating?
No. I think that's right. On the short list, you don't see, well, Sherlyn Eifel's name has been bandied about, but yeah, exactly. I think we all know that. And I'm really happy that you brought up that point, because being the civil rights queen was a double-edged sword. It was a factor that some brought up when they were opposing her nomination, saying that her experience was too narrow. That's what the ABA essentially is saying, because it's in the field of civil rights. And it followed her onto the bench, as it did for Judge Higginbotham and Judge Carter and all of those judges, with litigants asking them to recuse themselves from cases on the basis that they couldn't be fair. And Motley famously, as did Judge Higginbotham, turned that argument on its head, saying that if having a background, if one's practice experience is going to be per se disqualifying, then no judge on this court could hear these cases, which is a nice place to land. Cheryl, did you want to offer a thought?
I just was thinking of Spotswood Robinson also as a pantheon of civil rights judges, and it speaks volumes. I think Evelyn's exactly right. It speaks volumes to where we are. Civil rights used to be bipartisan. Now open hostility to the idea. So it's kind of a quite sad moment we're in.
Okay, so we're just about at time. So what I should do is, first I should just note that, I should thank Professor Brown-Nagin for writing such a wonderful book. I mean, a lot of people have thought about Constance Baker Motley and her biography. I did before, but it seemed such a challenge to try to figure out kind of what's going on. Motley she is the civil rights queen, or was. As Professor Brown-Nagin says, it's hard to kind of get behind the persona. But of course, this is what the book shows, that the persona actually is the thing to be analyzed and grappled with. So thank you, Professor Brown-Nagin, for writing such a wonderful book. It's going to be read by a lot of people. Thank you to the panelists for wonderful commentary. And before we leave, I think we have just a bit of a closing remark by Maya Bergamasco from the Harvard Law School Library. But thanks everybody for coming.
Thank you all.
Thank you. Thank you, Professor Mack. I'd like to echo exactly what Professor Mack just expressed. Congratulations, Dean Brown-Nagin, for the publication of this tremendous book. Professors Higginbotham and Cashin, for your insightful remarks. and of course, to Professor Mack for moderating. Thank you to the audience for their thoughtful questions. And I'd just like to quickly share the next event in the Faculty Book Talk series. It's for the book Lakefront Public Trust and Private Rights in Chicago. The book talk will be next week, February 15th at 12:30 p.m. on Zoom. You can register and read more about the event on the HLS Library website. Once again, thank you again to our speakers and enjoy the rest of your day.